Quick note, before we start, this is educational content only, not legal advice. Use it as study support and read the full case for complete context. This is one of those landmark cases that shapes how lawyers think. Starting work without a signed contract can create a legally binding agreement on terms you never intended. In RTS v. Molkerei, a dairy company and an automation supplier found that out the hard way. Learn what subject to contract really means, how conduct can override written clauses, and the one step you may want to take to protect your business. Let's break down this landmark case in plain English. Alright, let's start with the real-world problem. This is the part that helps you understand what was going on between these two companies before the legal battle erupted. Picture this. A dairy giant wants to automate its yogurt packaging line, so it hires a tech supplier to design and install a custom system. The deal is complex, involving millions of pounds and months of work. Both sides know a detailed contract is needed, but time is tight, so they begin with a letter of intent. This is a common business situation, starting work before the final paperwork is signed, but it sets the stage for a classic contract law showdown. The parties exchanged a letter of intent that contained a crucial phrase, subject to contract. In law, those three words generally mean that no binding agreement exists until a formal contract is signed. They signal that negotiations are still ongoing. Here, the letter also referenced the buyer's standard terms, which included a limitation of liability clause capping the supplier's liability at a set amount. But here's the catch. The letter was only intended to cover initial work. Even after the letter of intent expired, the supplier kept working and the dairy kept paying. Draft contracts were emailed back and forth, but no final version was ever signed. In everyday business, this might feel like a handshake deal, both sides acting as if an agreement exists. Legally, however, the absence of a signature left a huge question mark over whether a contract had formed at all, and if so, on what terms. As often happens with large projects, the scope changed, and the supplier claimed extra payment for additional work. The dairy pushed back, arguing that any contract included the limitation clause, which would drastically reduce what they owed. The supplier countered that no binding contract existed, or if it did, the limitation clause wasn't part of it. Millions turned on this legal wrangle. Now we get to the heart of the case. The law on contract formation can get technical, but I'll break it down so you can spot the red flags in your own transactions. At its simplest, the court had to decide whether a contract existed between RTS and Molkerei, and if so, what its terms were. This isn't just academic. Every business that starts work under a letter of intent faces this risk. The answer determines who bears the financial blow when things go wrong. The phrase, subject to contract, creates a strong presumption that no legal relations are intended until formality is completed. Usually, it acts as a safety net, allowing parties to negotiate freely without fear of accidental commitment. But here, the dairy argued the net had holes, that the parties' conduct later removed that protection. The law doesn't just look at what parties say, it looks at what they do. If you act like you have a deal, performing obligations, accepting payments, behaving as if terms are settled, a court may find a contract by conduct. This is the tension. Written phrases like subject to contract versus real-world actions. The Supreme Court had to decide which spoke louder. The Supreme Court dropped a bombshell that changed how letters of intent are viewed. Let's walk through what they held and the legal rule that now applies. The court unanimously ruled that a binding contract had come into existence after the letter of intent expired. Crucially, it found that the contract was on the terms of the draft, including the limitation clause that caps the supplier's recovery. RTS could only recover a fraction of what it claimed. This shocked many because it seemed to punish the party that had done the work. The legal test is objective. Would a reasonable outside observer, looking at all the parties' communications and actions, conclude they intended to be bound? The court said yes. Here, work had been done, payments made, and the only logical explanation was that a contract existed. The formal signature was a mere formality that both sides had waived. Perhaps the most critical legal point, a subject to contract clause, can be waived. It's not a permanent shield. Here, the parties' continued performance after the letter expired without insisting on signature was enough to waive the clause. The lesson? If you want to keep the protection, you may want to actively maintain it. Don't let action drift into commitment. To really get this case, you need to understand how the judges thought. Their reasoning gives us the toolbox for predicting future outcomes. The court didn't ask what the parties secretly intended. It looked at their outward behavior, emails, meetings, payments, and the sheer fact that RTS continued to build the production line. If it walks like a contract and quacks like a contract, it's probably a contract. This objective method prevents people from escaping promises they've clearly made. The fact that RTS had completed a substantial part of the work and Molkerei had accepted and paid for it was powerful evidence. In contract law, partial performance can show that an agreement is more than just talk. But here's the twist. Performance can bind you to terms you didn't fully read or agree on, like that limitation clause. The draft contract containing the limitation clause had been sent and discussed, and neither side objected to it at the time. By carrying on, they were taken to have assented to it. This is a harsh but consistent principle. If you don't object to a term before performing, you might be stuck with it. Always read the fine print, even in draft form. The judges emphasize that a contract doesn't need a formal signature to exist. While signature is strong evidence of intent, it's not a legal requirement. A contract can form through email exchanges, oral agreements, or even pure conduct. This case is a textbook example of how outdated the "we never signed anything" defense can be. Let's turn all this legal theory into concrete steps you can take to avoid the same trap. These are the red flags and safe practices you need. Every time you start work without a signed contract, you're rolling the dice on what terms a court will find apply. The terms might belong to the other party's draft, or to your own standard terms, or to something pieced together. The worst case? You're bound by a limitation clause you never intended to accept. This is a real and expensive risk. Letters of intent are useful for getting started, but they may want to be managed like a ticking clock. Set a clear expiry date and stick to it. Never let work continue beyond that date without either signing the full contract or issuing a new, equally protective letter. If you don't, you risk sliding into a contract on default terms. If you may want to use a letter of intent, spell out exactly which terms apply during the interim period. State that no binding contract exists until a formal agreement is signed, and confirm that any performance doesn't imply acceptance of the other party's terms. Also, agree on what happens if no final contract is signed, who bears the cost of work done. This case shows that contract formation can be a minefield. If your project is high value, involves custom work, or starts under time pressure, get a lawyer to review your letter of intent and draft terms. A few hours of legal advice can save you from a multi-million-pound mistake. Don't wait until the dispute arises. By then, it's too late. That's the practical version of what matters most. The big idea is to understand that starting work without a signed contract can create binding obligations, including onerous terms you never read. Compare the right details, manage letters of intent carefully, and avoid rushing into an expensive decision without context. If this helped, like and subscribe for more practical guides that help you understand contract risks, compare terms, and make smarter business decisions with confidence. Remember, this is a summary for study purposes. Always read the full case.